And still on the Meru governor impeachment, the Senate may have handed Meru Governor Kawira Impeachment a political lifeline by rejecting to uphold her impeachment by the county assembly. However, queries abound on what next for the politically troubled Mount Kenya East County. Legal pundits opine while she may have escaped ouster, for the second time in a row, the political bruises remain, and it will take much more than a vote to calm the political tensions between the governor and other county elected leaders. Our reporter Abdiaziz Hashim had a sit-down with pundits to examine the legal and political power plays in impeachment of county bosses.
Even before the dust settles on the verdict by the Senate clearing Meru Governor Kawira Impeachment of impeachment charges, the verdict remains fodder for debate. At the fore are legal pundits who have hailed the verdict but maintain there is more than meets the eye.
First of all, we want to congratulate the Senate for the amazing job that they have done in the last few days. This was the 14th impeachment that they have handled, and by now they have already set the jurisprudence on what is the basis for impeachment in this country and what the county assemblies have to satisfy the Senate before they can impeach a governor.
Constitutional lawyer Kome Emerson argues the ruling sets a precedence that will perhaps slow down impeachment motions by the county assemblies that in some cases are politically engineered.
The Senate has been very emphatic that once a county assembly makes some allegations, for example, the allegations made against Governor Mwangaza about nepotism and misappropriation of funds, that they actually have to present evidence in terms of the actual paperwork that they allege has been which is the proof of the allegations, and they actually have to come and present a credible case in the Senate. Unfortunately for the Meru County Assembly, this was not the case.
Article 181 of the Constitution stipulates that a devolved head can only be impeached on grounds of gross violation of the Constitution, committing a crime, abuse of office, and physical or mental incapacity to perform the functions assigned to the office of a governor.
The four grounds of impeachment under Article 181 must be clearly proven. A basis must be laid, a proper basis must be laid under Article 181 for the county assembly to proceed to impeach the governor. And I think for the county assemblies all across the country, they have to go back, they have to look at Article 181, look back at all the 14 impeachments that have come before the Senate, and look at what really moved the Senate, and realize that today we cannot impeach governors on the mere allegations, and you have to actually make a proper case.
Abel Suma, an advocate of the High Court, says Parliament should fast-track enactment of the impeachment bill of 2018. This, he argues, could end the culture of impeachment of county bosses on political grounds.
Around 13 years since we enacted the Constitution, to finally have an impeachment bill, or rather an impeachment act, to ensure that now going forward we have clearly laid out procedures and the standards to be met, so that the judicial pronouncements that have so far been made from the case of Martin Wambora, from the Mike Sonko case, it's now time that all such judicial pronouncements are now codified into a statute to avoid such embarrassing situations like the one that we have just experienced in Meru.
The proposed bill seeks to harmonize procedures to be applied in considering a motion for removal of a president, governor, deputy governor, cabinet secretary, or even a county executive committee member. Moses Dagai, a constitutional expert, says it is time to have a candid conversation on how impeachment motions are introduced and debated in the counties.
It is time the roles of county assemblies in terms of granting governors an opportunity to be heard before the county assembly during the impeachment process, it's time that such processes are codified to ensure that even a governor gets a fair hearing before the county assembly.
And we should not allow such grievances to be able to impeach governors. Such kind of grievances should not even reach the Senate. We should have a way of filtering these non-essential issues which can be sorted out at the county level.
Additionally, political experts are of the view that the governor is not out of the woods yet. She will have to rely on the county assembly to transact county businesses, while operations within the county executive may not be rosy either, owing to the rift between her and her deputy. History has shown a pen chart county assemblies to impeach governors, raising queries on the triggers. Since the advent of devolution 10 years ago, over 10 impeachments have been tabled before the county assemblies. Former Embu Governor Martin Wambora went down in history as the first governor to face more than 4 impeachment motions and survived. Others who were impeached and survived were former governors Mwangi wa Iria, Paul Chepkwony, Granton Samboja, and the late Nderitu Gachagua. Those who are not so lucky were former governors Mike Mbuvi Sonko, Ferdinand Waititu, Mohamed Abdi Mohamud. However, he was reinstated by the courts. Abdiaziz Hashim for Easy Friday.